Okay, so let's off on page 10. Want to go to page 15. So C, every search and seizure. Like arrests, every searches and seizure is reasonable to be valid under the Fourth Amendment. Reasonableness here usually means that the police must have obtained a warrant before conducting the search, but there are 6 circumstances when a warrant is not required. 1, the general approach. 2, governmental conduct required. 3, physical intrusion into constitutionality, protected area, or violation of reasonable expectation of privacy. Under that, there's standing, search of third-party premises, and no automatic. I was wondering if all 6 of those exclusions would be discussed, but it seems there's only 3 sections under the header of evidentiary search and seizure. So there are 6 circumstances when a warrant's not required. We will see that later. So for the general approach for evidentiary search and seizure, use an analytical model of the law of search and seizure requires answers to the following questions. So this is a useful analytical approach. A, does the defendant have a Fourth Amendment right? 1, is there governmental conduct? 2, did the defendant have a reasonable expectation of privacy? B, if so, did the police have a valid warrant? And C, if the police did not have a valid warrant, was the search within one of the 6 exceptions to the warrant requirement? And 2, governmental conduct required. So the Fourth Amendment generally protects only against governmental conduct and not against searches by private persons. The term governmental agents here, publicly paid officials, and those citizens acting in their direction or behest. Private, private, what again? Private freight carrier opened a package and resealed it. Police later reopened the package. Package to determine whether it was cocaine was not a Fourth Amendment seizure, even though the testing went beyond the scope of the original private search. United States versus Jacobson, 1984. Third is the physical intrusion into constitutionally protected area, violation HTML. Of reasonable expectation of privacy. There are 2 ways in which searches and seizures can implicate an individual's Fourth Amendment. Romanet 1, search or seizure by a governmental government agent of a constitutionally protected area in which the individual has reasonable expectation of privacy. And Romanet 2, physical intrusion by the government into a constitutionally protected area to obtain information. The government's, here's an example. The government's installation of a GPS tracking device on a vehicle and the use of the device to monitor the vehicle's movements constitutional intrusion into a constitutionally protected area. For example, it was a trespass as to the vehicle, and as such was a search governed by the Fourth Amendment. United States versus Jones in 2012. Standing. It is not enough merely that someone has an expectation of privacy in the place searched or the item seized. The Supreme Court has imposed a standing requirement so that a person can complain about an evidentiary search or seizure only if it violates his own reasonable expectations of privacy. Rackus versus Illinois in 1978. Whether a person has a reasonable expectation of privacy generally is based on the totality of the circumstances, considering factors such as ownership of the place searched and location of the item seized, Rawlings v. Kentucky, 1980. The court has held that a person has a reasonable expectation of privacy anytime, Romanet 1, she owned or right to possession of the place searched. 2, the right searched was in fact her home, or the place searched was in fact her home, whether or not she owned or had a right to possess of it. Or Romanet 3, she was an overnight guest of the owner of the place searched. Minnesota v. Olson, 1980. 1. Search of a third-party premises. Standing does not exist merely because a person will be harmed by introduction of evidence seized during an illegal search of a third person's property. Example, a police officer peered through the closed window blind of lessee's apartment and observed lessee and defendants bagging cocaine, when defendants left the apartment, the officers followed them to their car and arrested them. The car and apartment were searched. The cocaine and a weapon were found. At trial, defendants moved to suppress all evidence, claiming that the officers peeking through the window blind constituted an illegal search. It was determined that defendants had spent little time in lessee's apartment and had come there solely to conduct a business transaction bagging cocaine. Held, the defendants did not have a sufficient expectation of privacy in the apartment. They were there only for a few hours and were not overnight guests. Moreover, they were there for business purposes rather than social purposes, and there is a lesser expectation of privacy in commercial settings. Therefore, the defendants had no Fourth Amendment protections in the apartment and cannot challenge a search. Minnesota v. Carter, 1999. Page 12. No automatic standing to object to seizure of evidence in possessory offense. Formerly, a defendant had automatic standing to object the legality of a search and seizure anytime the evidence obtained was introduced against her in a possessory offense. This allowed a defendant to challenge the search without specifically admitting possession of the items. Because the defendant at a suppression hearing may now assert a legitimate expectation of privacy in the items without his testimony being used against him at trial, see Simmons v. United States infra, the automatic standing rule has been abolished as unnecessary. United States v. Salvucci in 1980. No automatic standing for co-conspirator. That a co-conspirator may be aggrieved by the introduction of damaging evidence does not give the co-conspirator automatic standing to challenge the seizure of the evidence. The co-conspirator must show that her own expectation of privacy was violated. United States v. Padilla in 1993. B. Things held out to the public. Generally, no expectation of privacy. The person does not have a reasonable expectation of privacy in objects held out to the public, such as the sound of one's voice, U.S. v. Dionisio, one's handwriting, U.S. v. Mara, paint on the outside of a car, Cardwell v. Lewis, the smell of one's luggage or car, drug sniffs by narcotic drugs, dogs in United States v. Place, 1983, Illinois v. Cabaye, Supra, account records held by the bank, U.S. v. Miller, 1976, or magnets offered for sale, Maryland v. Mackin, 1985. Compare squeezing luggage. I'm not going to compare these. And dog sniffs at traffic stops. I'm not going to compare these right now because they're not really relevant to what I want to know. Dog sniffs at entry to home. Number 2, open fields doctrine. Furthermore, under the open fields doctrine, areas outside the curtilage, dwelling house, and outbuildings, in other words, are subject to police entry and search. These areas are held out to be to the public and are unprotected by the Fourth Amendment. The court will consider the building's proximity to the dwelling, whether it is within the same enclosure such as the fence that surrounds the house, whether the building is used for activities of the home, and the steps taken by the resident to protect the building from the view of passerby. Oliver v. United States in 1984. Even a building such as a barn may be considered to be outside the curtilage and therefore outside the protection of the Fourth Amendment, U.S. v. Dunn, 1987. In addition, the Fourth Amendment does not prohibit the warrantless search and seizure of garbage left for collection outside the curtilage of the home. California versus Greenwood, 1988. Page 14, flyovers. The police may, within the Fourth Amendment, fly over a field or yard to observe with the naked eye things therein. California versus Cirillo, 1986. Even a low 400 feet flyover by a helicopter to view inside a partially covered greenhouse is permissible. Florida versus Riley, 1989. Plurality decision based on flight being permissible under FAA regulations. The police may also take aerial photographs of a particular site. Dow Chemical Company versus United States in 1986. Compare technologically enhanced searches of homes. The Supreme Court has held that because of a strong expectation of privacy within one's home, obtaining by sense-enhancing technology any information regarding the interior of a home that could not otherwise have been obtained without physical intrusion constitutes search, as well as the technology in question is not in general public use. Kyla versus United States, 2001. Use of thermal imager on defendant's home from outside the curtilage to detect the presence of high-intensity lamps commonly used to grow marijuana constitutes a search. Automobiles. This is what we're getting at. A police officer may constitutionally reach into an automobile to remove papers to observe the auto vehicle's identification number. New York versus Class, 1986. However, the police may not covertly and trespassorily place a GPS tracking device on a person's automobile without a warrant. U.S. versus James. That was underwhelming. Searches conducted pursuant to warrant. To be reasonable under the Fourth Amendment. Most searches by criminal law enforcement officers must be pursuant to a warrant. The warrant requires